Welcome to Lecture 3. This is about the Ontario court system and the judges that make the decisions and how the courts are made up. And of course, we've seen decisions that we're not too crazy about, and you will see some good decisions. And as environmental impacts are being seen more and more, it's more and more important that we understand it. And especially since some of you may be in court someday presenting evidence, not for some other reason. So here is an outline of Canada's court system as set up by Sir John A. Whoops. And ultimately we have the Supreme Court of Canada. Any decision made by the Supreme Court of Canada is the final decision. And down below you can see that our court system is divided into three sectors. One is court-martial court, so as you can see it's a military court, so it's dealing with the armed forces. Then there are the provincial courts, and there is the federal court system. And federal court deals with federal issues and federal responsibilities that were given to them in the Constitution. So pollution on federal land, and if it has an environmental assessment and it's going through in a federal environmental assessment hearing, the decisions would be made by federal administrative tribunals, and it is possible for the federal court to either comply or overrule certain parts of their decisions, which is quite frightening, actually. There's also the tax court, again, handling monies and spending money ultimately is dealt with by the federal government, and both of these can have the appeals made in the Federal Court of Appeal, and if there is a problem, then it goes to the Supreme Court of Canada for a final decision. So we'll focus more on that with Ontario. And in Ontario we have our provincial courts, and it is composed of the Court of Justice, and it is made up of two divisions, which I'll show you. And decisions from the provincial courts can be appealed, and they go to the provincial superior courts. They in turn can be appealed, and those appeals are forwarded to the Supreme Court. Now the Supreme Court has a number of appeals that it receives every year, and it doesn't accept or hear all of them. They can decide which ones they are going to have presented to them, and they choose the ones that will have the greatest impact on the Canadian society. For example, the right to die came up again, and this time the court decided that yes, people have a right to determine the way they're going to die. And interestingly, it had been presented to the court back in the 90s, and they had decided against it. So this is one rare occasion where the Supreme Court has agreed to readdress an issue, and it's good because it shows how the court changes with society's values, which it's supposed to do, and also keep our conscience too, right, through the Constitution. If we're going too far one way, it's going to say, hey guys, we got to rethink ourselves. Also, if there have been any tribunals, for example, the Environmental Review Tribunal that may have heard a hearing through the Environmental Assessment Act or the Environmental Protection Act, its findings go to the provincial courts, and the provincial courts may overturn some of the decisions that the tribunals have made. And you've heard me talk about how well qualified some of these people are that sit on the boards, and I think it's a really good thing that there is the power to overturn their decisions. So the Ontario court has two divisions. First is the Superior Court of Justice, and it here's criminal, civil, and family matters. So it has three branches that divide out into family, divisional, and small claims court. The Ontario Court of Justice is a lower form in the provincial division, and it hears provincial offences. So It's not just the Provincial Offences Act, it would be provincial offences, so offences under the EPA offenses under the OWRA. This is where it would go. If there had been harm to a person, it would go criminal. Or if you can show that there had been intent to harm, then it would go criminal. So this is another way to think of it too, is that the provincial division is civil matters and everything else is civil and criminal. The great link is to the Ontario Court page. And here it shows the sections. We have the Ontario Court of Appeal. And you can see they heard here in 2010, they heard 1,600 cases in 1 year. The Superior Court of Justice, all civil cases, and the more serious cases under the Criminal Code of Canada, and then we're into family issues, divorce, separation, payments, small claims court, and appeals and judicial review of decisions that have been made in review tribunals. So the Court of Justice is the one where the environmental offenses would show up here with the provincial offenses. And you can see that there are other themes in here, and it's not unusual for all of them to be presented in front of a judge in one day. So for example, I went for an environmental trial, and I went in and sat and watched the trial that was occurring before us, and it was a young offenders trial. And the young offender came in handcuffed and shackled, and it was a rape charge, and he had raped 3 girls. He was accused of it, and the 3 girls did not come to testify because they were afraid of repercussion. So the defense said they had no proof now. They couldn't go ahead with the trial. So this guy was off free. So somebody went over, undid his handcuffs, undid his shackles, and he walked away. And it was a very creepy feeling. So these judges and justices, see that it's a judge or a justice of the peace that will hear these trials, may not be specialized in all of the knowledge of these pieces of legislation. So it's up to the lawyers to educate them. Now these judges and justices of the peace, this is what they have to do to qualify. The provincial judge is appointed. He has been a lawyer for a number of years, so he has a wealth of experience and knowledge, and he or she actually oversees the work of a justice of the peace. And you address the provincial judge as your honor. And if you're ever not sure if it's your honor or your worship, say your honor. If it's a justice of the peace, you have just flattered them. And if it's a provincial judge, you picked the right title. So the justice of the peace doesn't have to be a lawyer, doesn't have to have a legal background. They just have some knowledge. They apply for the job. It's posted in the newspaper. I have seen postings in the back of Kawartha Lakes this week, and they will say there are positions for the justice of the peace in Lindsay, Beaverton, that lists the cities where they need them. And they apply and they go through an interview process, and they may or may not get it. We had a prof at Sir Sanford apply. He taught in the law program, and he had a M&R background. Actually, they've had two profs that had M&R backgrounds. One used to be a CO, and he got the job as a JP. Actually, they both got the jobs as JP. And something to remember is that you saw the realm of cases a justice of the peace will hear. So their decisions can be appealed, and well, all of them can be, but if the justice of the peace's one can be appealed, and they will go to the provincial court judge that has been assigned to them. And I can give you a case where the provincial court judge found an error of judgment on behalf of the Justice of the Peace, and he overturned the decision. So you can go through this at your leisure. It's just showing what a Justice of the Peace has to have to qualify to get their job. It starts off with a university degree, and notice the or down here, so it's only one of these, and a degree from an institution other than the university that is authorized to grant the degree under the Post-Secondary Education Choice Excellence Act. So that would include colleges. Oops, got trigger happy there. I met a Justice of the Peace who used to work in the courtrooms as a clerk for lots of years. So he had lots of legal experience, and he just got to know the judges really well. And he applied, and he got the job as a Justice of the Peace. So here is your typical courtroom. Nothing really fancy. Seating area here, anybody can sit where they like. There's no assigned seating. Whoops, trigger happy again. The judge is at the front. In front of the judge will be, or possibly to the side, is the clerk. The clerk keeps track of what cases are being brought forth to the judge that day, and the reporter records what is going on. So it's like everything being dictated, and they will sit there and type every single word you say, which is a little unnerving. They also have a tape recorder so that they can go back and listen to things that they may have missed. The witness sits beside the judge, and it's recommended that you go in there and actually you may be in a box beside the judge, or there may be a box right over here facing the judge. And the one I was in, where it was facing the judge, it was just a bar, so you went in and you held onto the bar or stood by the bar and faced the judge and gave your testimony. And then when you're by the judge, there is a chair, but it's recommended that you stand and wait for the judge to say that you can sit. They'll offer it to you. The accused sits over to the other side. They're not in a box like this. They sit at a desk, and they listen to the case. Everyone should be in the room before the judge or Justice of the Peace comes in, and it's just like TV. They do the all rise. Judge comes in, Judge or JP comes in, sits, everybody else can sit. And one trial I was at, the JP was late. Could have been because he had another trial, I don't know. But the accused came in, and he sat down, and he was waiting, and he got bored. So he got up and went to make a phone call while we were waiting. And while he was away, the Justice of the Peace came in, and he sat down, and he, met the two lawyers. We have the defense sitting on to the left and the Crown prosecutor sitting to the right. And then he went, "Where's the defendant?" And his lawyer had to say, "Well, he just popped out to make a phone call." And the look on the JP's face, it was kind of like this guy just lost. It was definitely a strike against the defendant. When you are a witness, you can come and sit in here. You can watch the trials that are going on before your case. You can sit in there while the judge comes in, and the accusations are read, or the case is read against the accused, and you can see how they plead. And then the judge or JP will ask all witnesses to leave the room, and you will sit out in a hallway and wait until you are called in to give your information. The reason is that they don't want you to get swayed by listening to other people's witness accounts. And that makes total sense, but it is unnerving sitting in the hall waiting for your turn. It's kind of like waiting to go into the principal's office. And when I had to go to court in Scarborough, sitting in the hallway, there was a real cross-section of humanity in those hallways, and I kind of got creeped out. In the trial itself, the Crown will present its evidence first, and that evidence will include their witnesses. When the witness comes up to give their information, you have to swear on the Bible that you will tell the truth. If you have a different religion, you can swear on your Koran or Torah, or I'm sorry, I don't know, whatever. And if you are an atheist, then you can just affirm that you will tell the truth. So you have quite a choice. So then after you've given your oath, you are asked questions by your lawyer. So it's easygoing at first, and you're asked to give information, and anything you read will always say just give yes or no answers, and that really applies to the defense, because when I have been questioned by the Crown, I have been surprised because the lawyer will go, tell me about what happened when you arrived at this address, and then it's silent, and then I have to go through everything I did. So you are allowed to take notes in with you because you want to make sure that you hit all the important points. Before you refer to your notes, you have to ask the judge if you can. And the judge will ask if your notes were taken immediately or quickly afterwards. And if you answer yes, and that includes going back to the office and writing it down, that's okay. And if you say yes, then the judge will likely let you use your notes. But keep in mind, once you are allowed to use your notes, they are open to everybody. The judge may have looked at them already, and this means also that the defense can look at them. And there was one case where someone in IEB finally got their polluter, and they went to court, and he used his notes, and he had all of his information in there, and at the bottom he wrote, got the SOB. And the defense lawyer read this and claimed that there was bias against the owner of this establishment, and the evidence was thrown out and the case was thrown out. So if you want to write that down, just think it and don't write it down. Also, make sure everything is dated. You cannot tear a page out of your notebook, and you cannot leave a blank page. So if you accidentally flip a page and you've skipped a page, you have to go back, put a line through it, and initial it and date it, and then continue on. And they'll be checking that, which is kind of weird. After you have presented your evidence, there is an opportunity for the defense to cross-examine you. After the and that's where you want to give yes or no answers. Take your time. If you are feeling that you are being pressured or bullied, you can turn to the judge or JP and tell them, and the judge or JP will step in. And sometimes they'll step in before you do. You can pause before you give an answer. They will kind of pressure you to give your answer right away. You don't have to. You may pause by asking for a glass of water, or you may have a glass of water already and you can take a sip, and while you're taking a sip, think about how you're going to put your answer together. Always remember that you're there to tell the truth. So you're telling what you saw, and no matter how they ask the question, you're just going to be saying what you saw and recorded. So don't get nervous, and just keep that in mind. And when you're being cross-examined, just think, well, nice try, but this is what happened. So when after you've been cross-examined, sometimes the facts may have been muddied a little bit. So your lawyer will want to go back and clarify a few points. So he will go back, question you again, and kind of sum up the points. And that's called redirection. After both sides, and then the defense will go up, present their evidence, present their witnesses. And of course, then there's the opportunity for redirection of the defense, and then the judge or JP will make their decision. Sometimes they'll make it automatically, sometimes they won't. Sometimes it will come out at a later date. It will be a written decision, and it's usually briefly worded, because if they add too much, the devil's in the details. There's opportunity for appeals based on the way that the judge based their decision. So court etiquette: if you are on the stand, arrive early. That's more or less to prepare you as much as to prepare everyone else. This way your lawyer, who is the Crown Prosecutor, can know that you are there, and he will tell you whereabouts to sit and guide you through what's going to be happening. Dress professionally makes a big difference. I was actually at a case where at the end the judge, provincial judge, commented on how professional the case had been presented and how professionally dressed everyone was, or professionally everyone looked. So it was a real compliment. Speak only when spoken to. Don't volunteer information. Stand up when providing evidence. So that's when you're in those little boxes, and you then sit when the judge or JP says that you can. And if there's a question you don't know, don't guess. Just say you don't know. And if you guess, the defense lawyer is just going to jump all over it. Here are the different types of evidence, and we'll get into each one. Direct evidence is using the 5 senses, and in any of these you want to answer who, when, what, why, where. And this is given by the witness who experienced any of those senses. So for example, they could stand on the stand and, go on the stand and say, yes, it really smelt. It was so bad that I had to go inside. Or yes, I smelt it in my house and it was so bad I had to close the window. So that automatically that proves adverse effect, and it helps to convict the defendant guilty of Section 14 of the EPA. Real evidence is the actual physical material that may have been collected, other than documents. So in environmental cases, it's usually water samples that have been collected, soil samples that have been collected, an axe, like that case in plating where they had the axe handle with the red paint that had come off when they opened the manhole, and then the red paint around the manhole. It'd be difficult to bring the manhole in, but they could take a picture of it and certify that and have the date on the picture and bring that in as evidence. And they would also have the person that collected it come in to say, yes, I collected it. And there's the opportunity for them to be cross-examined. So there was a case where a environmental tech had been out at a landfill and leachate was going off-site. So it was a conviction under the Water Resources Act, Section 30. And went to court. He was on the stand, had done his testimony with the Crown, and when he was cross-examined, the defense brought out the protocol, MOE protocol for sampling. And he had the book in front of him, and he said, well, it says that you're supposed to do this. Did you do it? Yeah. And then you're supposed to do this. Did you do that? No. It says here you're supposed to do this. Did you do that? No. And he kept going through and found all these holes in the protocol that the tech should have done, and it was thrown out. So all of a sudden that evidence couldn't be used, so they couldn't prove that the water had been impaired, and the case was tossed and the defendant got off. Documentary evidence is the original document itself, so it could be in the ECA, it could be lab results, and when it's lab results, someone from the lab has to be in court to assure that the results are correct, and there's usually a certification stamp on it. Sometimes the judge will want that person on the stand, and sometimes they don't ask that. So it all depends on the judge, but someone from the lab has to be there just in case. Secondary documentary evidence is where the original has been lost and the only thing that's left is a photocopy. And the best example I can think of is old C of A's. and not UCAs, but C of A's that were issued like back in the 1970s. The files are still with the Ministry of the Environment, so they would pull out the file. The original's gone. I mean, it's from the 70s. It's, it may have fallen apart or it just got lost in the shuffle somewhere. But there is a photocopy of it. So they know that that is the original C of A. So they would go into court and they would say, yes, this is a copy of the original. We can assure that. And if there's any questions, we have further documentation that refer to the to the C of A, dated this date, and there's the date, so it is the original. Expert evidence is where they have an expert come in to give their expert opinion. So if it's a question about the hazardous effects of a contaminant, they may have a chemist come in or a doctor come in that could provide that information, or they could have an engineer come in about the structural integrity of a building, or a hydrogeologist to come in and talk about the flow. When these people come in, they have to bring in their resume, and there is a hearing within a hearing, and in that hearing the expert witness would go up on the stand, and the two lawyers have copies of the resumes, and if they have any questions they can ask them, and they just go through the history of this person, and then usually both lawyers agree that yes, this person can proceed as an expert witness. They're not cross-examined at the time. The defense will wait until later to do that. This just establishes that they can come in as an expert witness. When it comes to the evidence, I mentioned the errors in sampling, so we have to make sure that we follow the proper protocols when we collect everything. And another protocol is the continuity or the chain of evidence, making sure that it goes from its sample point to the lab for analysis without any tampering. And it has to be proven that that was the case. And it's the responsibility really of the defense to try and prove that it could have been tampered. So if a well sample was collected and the well cap wasn't locked, the defense may go in, well, how do I know that someone didn't go in and spike those wells the night before? Right? There's an example there. So let's say someone's gone in to a locked well, taken the cap off, collected their sample. They have dated the label, so they can show in court that yes, I collected this sample, it was me because there's my name on it. You put it in the cooler, you're following proper protocol, but it's 6 o'clock in the evening, the end of the day. It's a 5-hour drive to the lab, so there's no way you can get there to drop it off, or you're just so exhausted you're worried you're going to fall asleep on the 401. So you stop overnight and take it in the next day. You would have to show that overnight there was no risk of it being tampered. The best place to leave it is in your car, in the trunk, locked. If you stop at home, that's fine, but you have to show that only you had a key to that car. So if someone else has a key, you have to collect it, and you have to prove, or at least testify, that it was on your person all night and there was no risk of someone tampering with it. MOE even has lockers at the office where you can go in, put your samples in the locker, and you can lock it, and you have the key for that locker. So you can say, yes, it was in this locker. I went back, picked it up, took it away. And in your notes, you should have a description of the sample, like water sample, any identification details, sample number, the date that you collected it, where it was collected. When you take it to the lab, there is a protocol there. They have a special sheet that the tech would sign. In other words, you are relinquishing custody of this sample and you are giving it to the lab, and the person receiving it would sign the other side. So there's proof again that it was received, and the lab person would say, yes, it's been received and in good form, right? It doesn't look like it's been banged about or weird, has this weird tinge to it. The fewer people in that chain, the less risk of something going wrong, right? Because the more people, there's just a better chance of something happening and the defense getting in there and proving that there was a problem. Here is an example of a legal sample label, and this is what is put on samples if you believe that the sample is going to go to court. So if it were a PET bottle, you would tear off, whoops, just where this tear is here, or it's peeled back. Here you would peel it, and you would take this portion of the label and center it over the top of the lid, and then the sides will go down and it will cover the area where it would twist off. So if the seal is broken, there's proof that, or there's a risk that someone has tampered with it. You'll notice that there is a serial number that will stay with the sample bottle. One sample number will stay with the EO. So the EO will take this chunk. There's another dotted line in here. That will then go into your notebook, and you can say legal sample number, whatever, collected. When it gets to the lab, the person receiving it will take this peel. And I was always terrified that when I was cross-examined, the defense lawyer would ask me the serial numbers of these legal sample numbers just to trip me up. But a friend of mine, she was terrified of the same thing, and it never happened. And now, in hindsight, it's kind of silly that they do something like that. They'd be more concerned about proving that it wasn't properly secured. Same thing with those paint samples I was talking about, how you collect them with razor blades and peel it off, and then you tap those samples in a petri dish. Same thing, you would take the long portion of the legal sample label and you would put it over the petri dish and it would hold it tight. So again, there's proof that no one tampered with it on the way to the lab.